bring them in if you want.
Railways Pension Trustee Co Ltd and Atos IT Service Limited.
Yes, Mr.
Good morning.
Good morning.
The precision with which those behind us are keeping an eye on the clock tells me apparently that I have until 10:38. Perhaps I have 30 seconds more because we're not quite starting at 10. If I'm not going to cut into my reply, I just say that so that the court is aware that those matters that I do need to conclude this morning I will be dealing with in as economic and speedy a way as I can.
Yes.
And I have the following to get through so that you know where I'm going. I have 3 short points to make on Article 7 in order to help to make good the submission that I made last night that there's no basis for Article 7 cutting in after 21.1.2. I want to pick up a few points on 21 that arise from some of your questions yesterday, and then I have to deal with Article 5, which is a final section of this appeal, which I think I can deal with reasonably quickly.
Yes.
Before I start, I just mention, in answer to my Lady Justice Applin's request that a table of all of the uses of determined be prepared. My team prepared one yesterday, and it appears that at least tacitly there's an agreement that it shouldn't be handed up until it's been agreed by the other side, and that makes obvious sense. And it hasn't yet been agreed by the other side, so I'm not going to hand it up. I'll have to deal with it after my learned friend has had a chance to talk to it if necessary. But there are multiple uses of the word determined, which your ladyship will be able to look at and see where they fall in the range of meanings that we've been talking about.
Thank you very much, and thank you to those behind you who've had to do that task.
Well, if Mr. Steer and Mr. Sawyer come to an agreement as to the contents of this document, it can be given to us at any time.
Precisely, my lord.
One would hope it's not too controversial.
No, I would hope not. I'd hope that it might be possible for me to hand it up, but it appears that that isn't the case. But let us not dwell on that. So, may I come back to Article 7?
You may.
Thank you. It would help if your Lordship, my lady, had in Bundle B, tab 11, Article 7, which appears at page 145. Invite your attention to 7.6 and 7.7 on page 147. 7.6 is the part of Article 7 that controls, principally controls the preparation, the timings of a preparation of evaluation, and therefore a schedule of contributions under Article 7.7. The process indicated by 7.6 speaks through a schedule of contributions in 7.7. The point I wish to make is this, that it as part of evaluation at which the Rule 21 shortfall assessment and contribution increase and, if necessary, benefit reduction process is taking place, that is evaluation that will engage through 7.6, 7.7. In addition, to the extent that the process in Rule 21 involves a Rule 21.1 STEM agreement between the trustee and the employer to increase contributions and or reduce benefits, the actuary will have given advice about that because of the requirement that he do so through Article 7.5, and that of itself would also engage the need for a 7.7 schedule of contributions. The position is this, first point. Even if the actuary prepares his opinion preparatory to setting up an Article 7.7 schedule of contributions, at the point where Rule 21.1.2 increases have been determined, and of course the premise for this is that we are right that there's no discretion, otherwise this point becomes irrelevant if my learned friend is right on that. Assuming no discretion over contribution increases to plug the 21.1.2 gap as far as can be done given the cap, at that point in time, not only does the actuary know what those increases will be, and so those could go into the 7.7 schedule already, he also knows what gap is left to be filled, if possible, by 21.1.4. He may not at that point have undertaken the exercise of the determination that he has under 21.1.4 as to how to allocate the benefit reductions, but he knows what the total benefit reduction will be, and he therefore knows at that point in time what the gap after that would have to be filled by the employer under Article 7.1.1 will be. He therefore has all the information required to prepare a coherent Article 7.7 schedule of contributions. And there's no coherent or rational basis for him ignoring the benefit reductions that are mandatory in that schedule and instead skipping straight to a position whereby he fills up the entire gap in the schedule of contributions that is created after contribution increases have taken place, with only employer contributions through Article 7.1. Secondly, as I've said, if if advice is given independently through perhaps a proposed amendment to reduce member benefits, independent of the Rule 21 process, that there should be benefit reductions through an agreement to amend or simply an amendment, the trustee must take advice from the actuary under 7.5, and that would engage 7.7. In that situation, the whole purpose of the 7.7 schedule would be to adjust contributions to make that are payable by the employer to take account of the benefit reduction. And if that schedule in that situation has to take account of benefit reductions, it would make no sense that the schedule in the context that I was just talking about should ignore benefit reductions. It's all part and parcel of the same principle of approach in producing a 7.7 schedule that is coherent and does lay down a plan that deals with all the different components and as a whole delivers the funding that is needed to make sufficient provision for all of the relevant pension rights. And the third point to make is this, and in making this point, it may assist to have Rule 21.1 open in front of you, which is at B tab 13, page 218. The point here is this. Imagine that Article 7.1 contributions are included in a schedule of contributions which prepared on the basis that effectively my learned friend would be saying it should be prepared, which is to ignore benefit reductions under 21.1.4 and therefore fill the gap entirely with 7.1 contributions from the employer. At the next valuation, under 21, Rule 21, the exercise is done all over again, and as you know from 21.1 STEM, what is taken into account in terms of future income stream in order to calculate the 21 type of shortfall are only, in terms of contributions, Rule 3 and Rule 3 contributions for present purposes. the stream of 7.1 employer contributions that is delivered by the previous schedule of contributions at the previous 21 valuation doesn't count for this technical purpose as a Rule 3 contribution, and therefore the whole question of benefit reductions and contribution increases under the Rule 21 at this next valuation will have to be blind to the fact that there are future 7.1 contributions due to be paid. The ones that have already been paid since the last valuation will be banked as assets, so they will count and they will reduce the shortfall. But the future stream of income from 7.1 wouldn't. And that, we say, isn't suggests that the idea that those 7.1, so the problem's just stored up for the future in terms of 21.14 for those members at that next valuation. So there are three reasons.
Sorry, but that doesn't make. First of all, if that's what has to be done, and that's what Rule 21 says, that's what it says, one might think. But also, what difference does that make whether you take into account, and this is, I'd like you just to extrapolate for me, if you do take into account little 4, you've still got a situation that on the next occasion, the problem that you were elucidating would arise in just the same way, haven't you?
It would, and it would have to be cured if my friend is right through the same process.
But it's just the nature.
It just carries the problem forward.
But it's the nature of the beast, and it's the
It
nature
is the
of
nature of the
21.
beast. Yes, it is the nature of it is that nature of the beast. But my point is that there isn't a coherent. Excuse me. I'm sorry. Please. It isn't a case of there isn't a coherent reason for simply putting to one side on the first valuation the benefit reductions that on our case 21.14 would deliver and has to deliver in preparing the schedule of contributions at that point in time. And I understand that your reply to my third point, my first 2 points, together what I said last night.
I was just trying to understand, and it seemed to me that this would occur anyhow, and it's just unfortunate.
Yes. Thank you. May I leave Article 7 and move to...
Just before you do...
I'm so sorry, my Lord.
Has any opinion been given under Article 7.7?
In this case? No. We haven't got there. What would have happened in relation to the 2016 valuation, which is still outstanding, as well as the 2019, is that if there'd been agreement over how the rule operates, the actuary would then have undertaken the relevant calculations, and would also be undertaking Part 3 deficit repair calculations as well, and a schedule would have been drawn up under Article 7.7, which would also have served as the Part 3 schedule. Not for this valuation. Oh yes, yes. One was done for 2013.
Okay.
Yeah, when there was agreement, because the situation wasn't as significant and didn't create the issues that have been created in the next 2 valuations.
And it hasn't even been done hypothetically.
Well,
If what you say is right, then every surviving member will have to pay 74% of their salary or whatever.
Well, with respect, what's happened, because we haven't been able to reach agreement, is that the only obligation on members is the historic 2013 one, which hasn't been updated and upgraded because we haven't had agreement at 2016 or 2019. And effectively, the scheme is limping along on the basis of historic contribution rates that were fixed at the 2013. And that's what everybody wants to solve, but Atos needs to solve that because it's not an up-to-date, coherent funding delivery going on at all. And various strategies to get through the interim period have been discussed. Essentially, it's based on that underlying premise.
Right, thank you.
Section 21. Just to go back, if I may, to make clear the nature of the process that we say takes place. First of all, you project all the contributions and you project all the liabilities. The difference is a shortfall with a present value of whatever. We said 10 million yesterday. However, conceptually, and this is the key point, that amount is not owed in the normal sense of that word, since much of the liability hasn't even accrued yet. It's not an amount that you should already have set aside. It's not a target fund in that sense, i.e. a fund that you want to have to make sure that all your accrued liabilities are met, which is the purpose of a normal accrued valuation approach and a funding approach, which underpins in principle the Part 3 process. Normally, if you have a deficit on that latter basis, you haven't got enough money in the bank, in the fund, or at that moment. And if you have a surplus, you have more than you need. A Rule 21 shortfall is not about what you haven't got, it's a projection in the very longest term. Conceptually, that is the position. What you then do is you adjust contributions under 21(1)(2), and from that point on, say, until the last active member leaves service, contributions are up by, let us say, 10%. Matters proceed. Over the next intervaluation period, experience, let us say, hypothetically, is exactly as the actuary predicted. That means inflation, asset returns, etc. It means retirements and resignations are as predicted. It means mortality is as predicted. What happens at the next valuation? The exercise is done again, and conceptually, the shortfall will have gone. It'll be zero. It's not like a funding deficit, a debt, if you like, that is there in the background until it is paid off. In the 21 shortfall sense, it's gone because the scheme redesign that took place previously meant that in the longest term, there is no longer a mismatch between the aggregate projections of what's going to be paid out and what's going to be paid in. How did that happen? It happened not because any hole got plugged, no money came from anywhere, but that wasn't what was needed. The shortfall at the previous valuation wasn't a hole in that sense. It was just a difference between two very long-term projections. And it happened, by what I mean by happened, it happened that the shortfall is assessed on the second occasion as non-existent because contributions at the previous occasion went up permanently. So they affect the long-term projection even at the next valuation. Obviously, if there is a shortfall, you have to redesign again. Increases in contributions and or benefit reductions. And conceptually, therefore, the shortfall at the time that the contribution increases or benefit reductions were put in place at the previous valuation was made good in the sense meant by 21 at that time.
But they're not set in stone, are they? Because at the next valuation, it might be worse, and then you've got to go through the process.
Absolutely,
again.
yes.
Or at the next valuation, it might be better.
Yes.
And then you're in 20.
Yes, then you're in 20.
For example.
Yes.
So they're not set in stone.
No, they're not set in stone. No, but unless changed, the contributions will
like all contributions,
like all
unless
contributions,
changed, they
yes.
are as they are.
But balance was restored, not, my lady, by deficit repair, which is different, but by redesign.
By
Under
redesign.
this rule. Yes, exactly. Second point on 21, to go back to discretion. First, as I've said yesterday, determine means just decide. Not helpful to create a one-word label for what determination means. Each time it depends on the context. Next point, there's nothing textual, for the reasons that we gave yesterday, to indicate that there's a discretion with the considerations to be taken into by the actuary, contended for by the trustee, within the rule. Nor is there anything contextual. In fact, the context suggests otherwise. First of all, there's a mandatory requirement to make good the shortfall by requiring at each step whatever value is available at those steps, 2 or 4, to be provided to make good the shortfall. That's what it says, shall make good, Rule 21(1) stem. No room, we say, there's no room within that requirement for the actuary, in effect, to undermine the purpose of the provisions by only allowing part of that value to go forward into the shortfall making good process required by Rule 21. Secondly, contextually, Rule 21(1)(2) requires the determination by the actuary to focus on increasing the contributions of members and the contributions of participating employers as determined by the actuary. If the actuary has the discretion contended for, in his discretion, therefore, he is also deciding the contributions payable by the employer, necessarily because of the lockstep, 60-40. And it's not suggested that the discretion, if it exists and is exercised so as to make the contributions more affordable for the members, in some way breaks that lockstep. So necessarily the discretion which it is contended the actuary has affects the interest of the employer. It's a fundamental break with the aspect of design of the scheme that we say requires full making good of the shortfall through Rule 21. It is also giving the actuary an entirely new role from the one he had under BRPS, where he has in his control both contributions for members and contributions for employers and benefit redesign. That's a very profound change, not reflected at all in the wording of Rule 21(1). And how is he to exercise that discretion where the interests of the employer are to be taken into account? The rule itself, if we are right, takes account of the interest of the employer by putting in place a cap which they have a right to waive. We say that context, based in part on the text of 21(1)(2), militates against the discretion contended for. Last point, if I'm so sorry.
And yet, once the last active member goes, the entire burden falls on the employer.
That's always been the case. Well, that wasn't the case under BRPS, and once 21(1)(3) was introduced in 2006, it was written into the rule that that would happen. But from the outset, because of Article 7, the employer picks up the burden. So what in essence the protection order in this context did was to, and the RPS order which laid down the rules did, is to replicate the BRPS approach with some tweaks, admittedly, but fundamentally the same. The shortfall has to be made good through a shared cost, potentially benefit redesign process. And the overlay that Article 7 provides is, if that, when it's been gone through, doesn't provide sufficient provision for all of the rights, then the employer will come in under Article 7. And subsequently, my lady, my lords, the statutory overlay that came in stages in 1997 and then after the 2004 Act created additional routes through which the employer would have to pick up the burden. But that's the principle.
Can I take you back? I know you're eager to run on. If this is a true discretion, would you say that, given the enormity of it, which you've explained, that an actuary would come to court for blessing of his decision in relation to how to divvy all this up?
Well, my learned friend's whispering loudly next to me, and he says that actuaries don't go to court for blessings.
But fiduciaries do.
But fiduciaries do, yes. And if it exists, I might need to think a little further about the practicality of that. But these sorts of decisions, weighing up the interests of employer and members, one would normally expect to be vested in the trustee with involvement from the employer, and not carved out and given to the actuary. The actuary has incredibly important functions, as my lady said yesterday. Lots of professional judgments have to be exercised, but this is a pretty fundamental new role beyond that which most actuaries would normally have to exercise.
And the other question I had is in relation to what you said about lifting the cap. And you said that's in the hands of the employer, and the cap is to protect the employer because it maintains the lockstep up to the 130. If the employer decides to get rid of the cap, the lockstep remains in place. So he drags the employees above the line with him. That's correct?
That is correct. Yes, exactly. Assuming there's no discretion in the actuary to look after the members' interests.
And
yes.
so do you say that the decision whether or not to release the cap is one which is subject to an employer's duty of good faith?
Yes.
Thank you.
And may I make the point, allied to that what the effect of the discretion contended for is to rewrite the cap to something lower that the actuary determines each time he does one of these Rule 21 processes. Written into the rules is a dividing line, presumably back in '94, considered to be appropriate as part of the deal of privatisation, which means that employers knew that they would have to pay, they themselves would have to pay contributions under 21(1)(2) to fill the gap at that stage of at least 130%. Yet that's being rewritten with a new flaw to be determined by the actuary himself at every single valuation. Because if he's going to decide the members' contributions in his discretion on the basis of affordability for them, that is automatically going to affect the floor. And that we say doesn't work. I mean, it works in the sense that it will happen, but it doesn't sit with the approach that the purpose of the rule.
I'm sorry to have delayed you. Thank you.
No, not at all. The last point on Rule 21 is prompted by a question raised by my Lord Sir Launcelot Henderson yesterday about whether the actuary can ignore the likelihood of opt-outs when both undertaking 21(1)(2) and 21(1)(4). I repeat the submission yesterday that under Rule 21, yes, he does, because he's looking at the position as it is at that moment in time. He's looking at the position about what the contributions will be going forward and what the benefits will be going forward for the current cohort of membership. That's what Rule 21 requires. Let us say, however, that the actuary, and he must, on our case, because there's no discretion, he must make the necessary calculations and feed those contributions, the contributions of value that come from 1 and 4 into the overall equation. If, on the other hand, he is convinced that at some point in time, whether it's very soon after all of this becomes effective, because this has an effective date, that members will opt out, it may very well be that all of them would go very soon. There might be some who wouldn't for some reason. But let's assume that they all are highly likely to opt out fairly soon. That doesn't leave the actuary with no remedy so far as ensuring that the scheme is properly funded. There is no choice, because it is the way the 21 scheme design is set up, which involves contributions being changed and benefits being redesigned potentially all the time through the life of the scheme. There's no choice about that. But Article 7 provides the answer to the concern that the actuary is just simply ignoring something that he thinks is going to happen in the future. That is something that he may very well be entitled to, and no doubt will be entitled to feed into his assessment of what additional contributions the employer is going to have to make to fill that final piece of gap under Article 7(1). And there, my Lord Justice Bean's question yesterday about, well, what happens about the fact that, of course, as soon as they opt out, they won't pay their share of the contributions. That's where that's taken into account, and the schedule of contributions will and could make provision for the employer to meet the contributions that any opting out members do not pay if they opt out. That's a sensible and coherent approach to ensuring that although the scheme has reached the point in its life where no longer can scheme redesign through benefit reduction and contribution increases make good the shortfall without it causing the last active members to leave. That is the consequence of the way the scheme was set up. At that point would at some point arrive, and it's now perhaps arrived. But what the actuary is able to make sure happens there and then is to ensure that the scheme will be properly funded through that schedule of contributions by the employers taking up and filling that gap. So not just filling the gap that exists immediately, but the gap that is predicted to arise once the members actually opt out. That, he's not prevented from doing that under Article 7. Indeed, he has to put together a schedule of contributions that does require contributions that will make sufficient provision. So that knowledge, that foresight of members opting out doesn't enable him to undermine the purpose of Rule 21(1)(4), but it does enable the scheme to be properly funded at that time through Article 7. Those are all of my submissions on both Article 7 and Rule 21. I'm now going to give you my submissions on Article 5.
Yes.
First of all, what decision precisely is being appealed and what is the issue? You can see in ground 7 at A586 how it's put. And I'm going to focus principally on ground 7B. That is the basis upon which we invite you to allow the appeal on Article 5. Cross-refer, please, to the judge.
Can we cross out 7A?
No, I'm going to explain why it's there. I think it's important that you understand why it's there. But 7A is, we submit that 7A is sufficient to deal with this matter. And may I just point out that the wording here doesn't make any reference to the cap. On one view, perhaps it should, but I don't think it makes any difference because my learned friend's submissions focus on the cap as being the lifting of the cap as being the objection, and you will have to consider whether lifting the cap engages Article 5, and similarly all of the other steps that are set in here. So to that extent, if this it doesn't technically engage debate on the cap, it doesn't really matter, because if you debate either any of the elements that are set out here, you will reach the same result. When I finish my submissions, I hope that it will be clearer exactly what I mean by that, but I wanted to make it clear that the wording, there is no express wording relating to the point that actually my learned friend takes, which is that it's lifting the cap that will engage Article 5 and is the mischief under Article 5 that he wishes to put before the court. And certainly, if you look at the judgment, at paragraphs 118 to 19, at A245, you'll see what the judge said. It's a brief treatment of the point. Perhaps I could invite you to read those two paragraphs.
Sorry, which two paragraphs?
118 to 119. And that reasoning fed into the answer to question 4, which appears over the page within the judgment. Article 5 of the Protection Order precludes Atos from agreeing to lift the 130% cap. So that's the ruling that we are in fact appealing. And
That's question 4.
that's question 4, lady, yes. Precludes Atos and the trustee from agreeing to reduce future service benefits under Rule 2114. Insofar as, in either case, this would be likely to cause active members to opt out. The final piece of the jigsaw, before I make my submissions, is Article 5 itself. Which is at B tab 13 again for the protection order. B tab 11. Page 143. I did take you to this, I think, previously, but just to remind you, it prevents an employer or a trustee from it prohibits an employer or a trustee from preventing a protected employee from participating in a relevant scheme or acquiring relevant pension rights in that scheme. The judge ruled, and we don't challenge this ruling, that acquiring relevant pension rights doesn't just deal with, if you like, acquiring them at the outset. It deals with acquiring them as you go along. And that therefore, if actions are taken by the employer during the lifetime of the scheme that prevent relevant pension rights that are no less favourable from continuing to be acquired, then that potentially engages Article 5. So that is the background. My overarching submission, which I support by two main planks, and the third plank that we'll deal very briefly with ground 7A is as follows. Article 5, we say, falls to be construed in such a way that increases in contributions or reductions in future service benefits resulting from or caused by the operation of Rule 21 cannot, at least in the ordinary case, be treated as giving rise to a breach of the Article 5b obligation. I'll come back to the ordinary case bit at the end. That's plank 3. But that is the fundamental point. What that means is that if there is discontinuance of the acquisition of relevant pension rights from an agreement between the trustee and the employer, the agreement of the employer, that would be under 21.1 stem, the agreement of the employer will not constitute a breach of Article 5. Whether that agreement embraces contribution increases under 21.1 stem or benefit reductions under 21.1 stem or benefit reductions under the first limb of 21.14. Equally, if discontinuance of the acquisition of relevant pension rights results from the actions of other actors, such as the actuary, in determining under Rule 21.1.2 or 4 what he is required to determine, the employer will not be in breach of Article 5 just because those actions of the other actor has resulted from the employer, for example, not agreeing to arrangements under 21.1 stem or waiving, or indeed not waiving, the cap in 21.1.2. And so it follows that the employer will not be in breach of Article 5 if it does something permitted under the rules which has the knock-on effect of a member opting out. And either, and I'm going to give you two circumstances, in any circumstances, if those preconditions are met, because it's not the employer who's preventing the active member from continuing to acquire those rights, it is instead the voluntary withdrawal of the member in response to a lawful operation of the scheme rules. And on that approach to the construction of Article 5, even if separately the employer acted unlawfully, for example, a breach of the duty of good faith, that would not, on this approach, be regarded as engaging or being a breach of Article 5 on the basis that Article 5 should not be construed as importing into the mischief at which it's aimed conduct on the part of an employer that would already give rise to a remedy separately. Alternatively, and this is the approach floated in our alternative ground of appeal 7A, all that I have said will be so unless the employer acts in an unlawful manner whilst at the same time undertaking the actions which it's permitted to do under the rules. And on that approach, one would have to construe Article 5 as encompassing some unlawful means carve-out from the general approach I've adopted, which is that if you do something under the rules, you're not in breach of it. The reason that this can be parked, I say, as a point in terms of this court's ruling, is that there is no suggestion of any breach of duty of good faith by Atos in any of the approaches that it's taken hitherto, or that if it refused to lift the cap in future, that would necessarily constitute a breach of, or there might be circumstances in which that would be. It is hypothetical. And so, absent any suggestion of good faith, one can approach it on the narrower basis that I've invited the court to do so, which is 7B.
But before you go on, I'm a little confused. I thought you said that good faith, breach of good faith would not be a breach of Article 5 because there would be a separate remedy. I misheard you. But now I think you are accepting perhaps that if, and you'll say we're miles away, but if there were a breach of good faith, then it would fall within 5.
I'm not saying, I'm giving you that as an alternative approach to the construction of Article 5. My principal point is no. That's dealt with by a breach of duty of good faith remedy, and it's not written in somehow to Article 5. Article 5 is specific in the context that we are talking about, lady, which is opt-out, which is a formal process of voluntary withdrawal from the scheme. In that context, my primary approach is to say it's voluntary. End of. Sorry, colloquial. But that's it so far as Article 5 is concerned. If there's an overlay of breach of duty of good faith, then that will be taken care of, and will lead to whatever remedies are appropriate. But we felt it necessary to deal with what might be the position if breach of duty of good faith had occurred. And another way of looking at it, which I don't put forward as my primary case, is that you in some way read that into Article 5, so that if there's a breach of duty of good faith, then what otherwise might have been the result under Article 5 is not the result. That's my alternative. I need to say one short thing about the wording that you see in 7A, get that out of the way. Article 5 is only engaged in relation to actions which are aimed at causing active members to opt out and or which employ unlawful means. On reflection, I'm not sure that the word or should have been an and or, because conceptually we don't envisage any present kind of conduct that is aimed at causing active members to opt out, which would engage Article 5 without it being unlawful. I just want to make that point. Now, let's move on, and I'll give you my two main planks in support of the overarching submission. First of all, the statutory scheme. It's implicit in the statutory scheme that shared cost arrangements may be provided by employers and of protected persons, and accordingly protected persons' contributions may increase in response to shortfalls, and that their future service benefits may reduce for the same reason. See, for example, Article 4.3 and Article 7.5, to which I'll come back in a moment. Accordingly, Article 5 must be construed so as to allow a shared cost structure, such as that in this section's rules, to operate. That is, to operate in circumstances in which contributions are increased and or benefits reduced to deal with the shortfall. It's also part of the shared cost arrangement that active members have the ability to opt out, and the fact that they might do so if the levels of contributions required to be paid by them are high, or because their benefits are being reduced, must have been objectively foreseeable at the time that the structure was set up. Article 5 plainly has as its purpose to prohibit employers from taking actions which render the rights which are conferred by the protection order nugatory. That those rights need to be read in accordance with the shared cost structure that is effectively recognised and built in and respected by the protection order. I showed you Article 4.3 yesterday. I'm not going to take you back to it. That makes it very clear that the protection order was promulgated with the RPS sections in mind, and that also any other schemes under Article 4 would or might include various shared cost mechanisms that would then operate in the way that this one does. Equally, 7.5, which I showed you yesterday, permits trustees to exercise the power of reducing benefits or increasing contributions, subject to actuarial advice, and that can only happen with advice from the actuary. So we would say that the central implausibility of the respondent's case, as it relates to agreements under Rule 21.1 STEM or agreements for reductions under Rule 21.1.4, or indeed the operation of the cap, is that effectively prevents the operation of the rules as they are set out and, we say, respected in the protection order. Even in relation to the cap, which is the bit on which fire was directed at the trial, and which specifically the judge dealt with in his judgment by saying that lifting the cap would be a breach of Article 5, it's part of the rules that employers enjoy the cap. It's plainly there for their benefit, and that's expressly waivable without the consent of the trustee or the actuary being required, subject, my lady, to the duty of good faith, of course. If it had been understood that waiving the cap was complex and that members might have an interest in the cap not being waived, you might have expected a more nuanced approach in the rules, perhaps for it to be subject to trustee consent, because obviously that would be a much greater control than merely the duty of good faith. On what basis, therefore, can the employer, exercising straightforwardly an option to waive the cap, because it means that there will be no benefit reductions to members, because then Rule 21.1.4 will not be engaged. One of the consequences of raising the cap is that although it might be in one sense against the interest of the employer to do so, because it has to pay more, it helps the members in the sense that although they will have to take a bigger contribution burden under 21.1.2, any question of their benefits being reduced may be removed. And if they opt out because the cap has been waived in those circumstances, because the contributions are too high, why should it be said that that engages Article 5? The alternative to waiving the cap is not to waive the cap, which is what effectively the Chancellor said was the only option open to the employer if Article 5 isn't to be breached. The effect of not waiving the cap is the converse of that which I've just described. It's to throw the burden, 100%, the remaining burden, onto members. At least under 21.1.2, they bear the burden only 40%. Under 21.1.4, they bear the burden 100%. So that, it would seem, would not be a reason either, in principle, why they should be prevented from doing it under Article 5 if there's a subsequent opt-out. We say that that consideration drives one to the conclusion that neither lifting nor not lifting the cap engages Article 5 if there's a voluntary waiver, a voluntary opt-out thereafter. Blank 2, in support of the overarching submission, the scope of the power by which Article 5 was made. Article 5 is made under the authority of Schedule 11, Para 6, which is at B 10 114. It falls into two parts, the general and the particular. 6.1 is the general power to make provision for the purpose of protecting the interests of protected persons. 6.2 is the particular power providing the Secretary of State with the authority to make many different types of provisions. The relevant one is 6.2b. Provision may be made that a person who is a protected person is not prevented from participating in some occupational pension scheme and acquiring pension rights under that scheme, dropping down. The exception to that is that the relevant exception to that is that he voluntarily withdraws from the scheme. In other words, we say that if...
Where's the voluntary withdrawal? I'm just looking.
Sorry? B2.
Thank you. Sorry.
My fault for not waiting for you to find that, my lady. And that we say would exclude any action taken by the employer that leads to a voluntary withdrawal from the scheme, which we say is an opt-out because there's a formal process for it. It means that any action by the employer does not engage Article 5 for that reason, because this power-making provision is clearly the provision under which Article 5 is made, and either, if Article 5 is to be read contrary to that, it's ultra vires, but that's clearly not the position. One needs to construe it in accordance with the power in which gave rise to it being promulgated. And as I said, voluntary withdrawal is a composite term, which we say means electing to withdraw. And if there's, in accordance with the rules, the process followed, then that engages that concept, and Article 5 does not apply in the situation contemplated. And I leave this point simply by saying that there are other examples in the protection order of protected persons being able to elect to waive the protections of the protection order. Article 12 is a good example, which goes to show that the statutory scheme doesn't expect members, does expect members in certain circumstances to be the authors of their own fortunes. That may be putting it harshly, but in reality, optional withdrawal from the scheme by opt-out through a formal process is one of the ways in which members can control their exposure to paying contributions when their benefits may have been reduced. The unlawful means submissions in relation to 7B I have effectively given in answer to a question by my lady, so I don't need to make them any further. Those are my submissions.
Thank you very much,
Unless you
Mr.
have any
Spink.
questions.
Mr. Steer? Mr. Green?
Lord. First, three brief observations on what's passed between my learned friend and the bench this morning. First, in relation to Article 7.1 and the schedule of contributions under Article 7.7. If the Lordships would be so kind as to open B11146 again, you've had it open on many. This is the balance of Article 7.1. It starts at page 145. As your Lordships know, the essential obligation for which Article 7.1 is providing is a contributions obligation on the part of employers. And as you see in the third line on page 146, the contributions which the employer shall make under that duty shall be not less than such amount as, in the opinion of the scheme actuary, shall be sufficient to make provision in respect of the rights specified. The actuary has to, in his professional judgment, express an opinion as to the sufficiency of the contributions, the actual contributions, which frankly is what Rule 21 is also referring to, but we'll deal with this shortly. The actuary, in his professional judgment, has to be able to give an opinion, effectively to certificate the sufficiency of the actual contributions which are proposed. And it is that, and only that, which is the subject of Article 7.7. In order to get into Article 7.7 on page 147, the actuary has to have been able to give that opinion, that actual contributions to be received will be sufficient. And as we know, the background to this case, and your Lordships can turn this up separately, is at B15, the Willis Towers Watson, the scheme actuaries' concerns and discomfort in this case are summarised at paragraph 2.7. Perhaps we should look at that. At B15 232, B15 232, and also at paragraph 620 at B15 237. At B15 232, he says at 2.7, as I explain at paragraph 620 below, I'm concerned to understand whether I, as scheme actuary, am under a duty to set active member contribution rates. He's referring to Rule 3BA there, but it's the same point for Article 7, where I do not consider it realistic that the contribution rate which I'm setting will be paid by active members and that the shortfall will be made good. This obviously applies to Article 7 as well. And 620, the same point is made. And it's hardly surprising that the scheme actuary, speaking professionally, is expressing that difficulty, not merely applicable plainly to Rule 3B, but also plainly to the process envisaged under Article 7.7. The second point I'd like to make concerning the exchanges this morning concern the, if I may use the expression, I don't mean to do so disrespectfully, the buzz expression that my learned friend has put before you, the sound bite, if you like, to get you to write it down, that balance under Rule 21 is returned not by deficit repair, but by benefit redesign. Balance under Rule 21 is returned not by deficit repair, but by benefit redesign. And this is the launch pad for the submission that you don't need to trouble yourselves with the fact that no contributions are actually going to be received. Don't trouble yourself with that at all, because it's all objective and theoretical. My comment in relation to this is that resetting contributions for a rate and a period is deficit repair, not benefit redesign. And if you look at Rule 21.1.2, that is plain. And it was plain from the exchanges between my lady and my learned friend today. We know Rule 21.1.2 operates on the lockstep 60-40 basis. Setting of contributions is not, in the context of Rule 21.1.2, is not benefit redesign. It's deficit repair under the operation of Rule 21.1.2, whose terms are not being affected at all. There remains the question of construction, which is at issue between us, as to whether the actuary has a substantive discretion exercisable in his judgment or not, which we're obviously going to come on to. The third point I wanted to make to you involves perhaps an apology to my lady for my whispered comments to my learned friend. What the transcript reveals, and what indeed I heard for today on day 15, at page 15, lines 9 to 11, 9 to 15, was that your ladyship put to my learned friend that on his case, such was the exceptional gravity of the discretion that the actuary was going to have to undertake under Rule 21.1.2, that the actuary would be expected, the word was would be expected to come to court. And it was that caused me to sotto voce say, well, well, look, as my lords, you'll know, actuaries have to come to significant decisions constantly in relation to the operation of pension schemes, and they do not, on a regular basis, or in my experience at all, trouble courts. Yeah. Is it theoretically possible for an actuary faced with a momentous decision to come to the court? Of course. So that's
both as perhaps in his capacity as the actuary, but also, and my question was based on if the decision is so momentous and the decision is actually an exercise of discretion, then he would want to be covered by the benefit of coming to court.
Yeah, well, my lady, yes. Though, of course, actuaries generally are made of sterner stuff.
Well, it depends.
Well, it depends. It depends.
It depends on the. It depends, as Mr. Spink would say, on the context.
Well, it's not. My lady, actually, the context would be whether you've got an extremely aggressive employer,
Exactly,
for
that's
example,
what
who's
it's
firing.
the political background.
Oh, no, that's all true, my lady. But what it doesn't depend on, I would respectfully submit, is the particular power which has actually been vested in the actuary. It depends on the circumstances in which that power is being exercised and the questions which arise.
You'll come to this, and I don't want to
I
delay
will.
you, but also, as you'll fully appreciate, Mr. Green, behind my question was, if this is a true discretion and he is a true fiduciary, then he would.
Well, my lady, my respectful submission, Wood is putting it far too highly, because on that basis, the actuary would, in respect of all his powers to determine and all of his discretions, be coming before the court. So,
Well, there'll be a colour chart, but we'll come to that.
So, an introductory point, an overview point. Your lordships have our supplemental skeleton. It's at A13 153.12 to 15. And I hope that your lordships have had an opportunity to read it and to absorb the points that are made in it. If not, please do take the opportunity to remind yourselves.
Speaking for myself, and I'm sure my colleagues, of course, we read it as part of preparation for the hearing, but I wouldn't care to answer questions. you focus on whatever you would like.
No, and indeed I will. And as you've seen, the basic thrust of it is to say, look, the case before you is clearly now going to be on Article 7. The appellant's case is going to be option B. That's the basic thrust of it. And once we've cleared away option A, then come on, now let's get down to brass tacks and see how the acceptance that option B is the appropriate construction actually then pans out in relation to the decisions which you have to make on this appeal. That's the point. And then, so the points I want to make to your lordships are this. It's apparent that our skeleton effectively correctly called the way in which this case was going to develop in front of you. The option B interpretation of Article 7.1 is now the interpretation that the appellants are running with. And under that option B, it is accepted that Article 7.1 does, in relation to the Atos Section, place on employers a freestanding sufficiency of funding obligation in relation to accrued and accruing rights of protected persons. As noted at paragraphs 7 and 8 of the supplemental skeleton, that's page 153.13, A13 153.13, as noted at paragraph 7 and 8, under option B, Article 7.1 is conceded by the appellants to, quotes, fill the gap after Rule 21.1 has operated. That is, on the appellant's case before you, having Rule 21 having, as a matter of fact, brought about a wholesale opt-out of active members, on the basis that with zero accrual of future service benefits, ceasing to participate as an active member in the section, and to have to pay contributions already inflated under Rule 21(1)(2) is the only choice rationally available to them. As to the inevitability of wholesale opt-out, this is consistent with what the appellants had frankly admitted and contended for below, as was recorded by the Chancellor at paragraph 55 of his judgment, A2, pages 30 to 31. Then, as the trustee's supplemental skeleton then points out over the page, paragraphs 9 to 11, A13, 153.14, once the application of Article 7.1 to fill the gap after Rules 21(1)(2) and 4 have operated is acknowledged, once the application of Article 7.1 to fill the gap after the operation of Rules 21(1)(2) and 4 is acknowledged, the real issue before this court then becomes which of the appellants and the trustee is right as to the construction of Rules 21(1)(2) and 4. Whichever of us is right will be the principal determinant of the size of the remaining gap that Article 7.1 is there to fill. It's not only the real, but it's the most important issue in this case. There is then a secondary determinant of the size of the gap that Article 7.1 will be there to fill. And that's paragraphs 12 and 13 of our supplemental skeleton on the same page. And that is the subsidiary issue of whether Article 7.1 cuts in to fill the gap after the operation of Rule 21(1)(2) or after the operation of Rule 21(1)(4. Now, there are actually arguments each way, more than the appellants give credit for, but it is very much a secondary determinant of the size of the gap that Article 7.1 is there to fill. Now, putting Article 7.1 to one side just for a moment, and just looking at the parties' respective constructions of Rule 21. My learned friend yesterday, and it's the transcript reference at day 1, page 113, lines 11 to 14. My learned friend yesterday characterised the trustee's submission as to the existence of actuarial discretion as, quotes, diminishing the amount of money coming in to meet the Rule 21 shortfall, unquote. But as your lordships will have picked up, the contrary is in fact the position. On the trustee's case, on the main issue as to whether the actuary's powers of determination under Rules 21(1)(2) and 4 confer a substantive discretion as to collectability of contributions, in respect of which he brings to bear professional judgment, shortfall contributions will be collected to the maximum extent possible, such that the shortfall is reduced in fact. Whereas, on the appellant's case, everyone opts out and no contributions are collected, so that the shortfall is not reduced under Rule 21 at all. The position is, therefore, directly contrary to that submitted by my learned friend at day 1, page 113, lines 11 to 14. On the trustee's case, the actuary bringing to bear professional judgment would optimise contributions coming in under Rule 21 to address the Rule 21 shortfall. That's his job, to try to make good the Rule 21 shortfall. It is the appellant's unremitting construction, producing as it does an inevitable opt-out, that would ensure that no contributions and no reduction occurs. And the irony, sorry, my lord.
No, I'm sorry, I don't want to interrupt you.
I'm sorry.
Well, I was just I mean, the thought was crossing my mind was, is it fair to say, without putting words into your mouth, of course, that the approach you are advocating is one that's really looking at the reality of the situation on the ground that has to be addressed, as opposed to a highly artificial construct, which may be what the rule properly construed requires, but is really the nub of the argument against it.
Exactly. We're looking at the reality, and we say that the rule properly construed does lead to the conclusion that that reality is enabled, a reality which involves making good the shortfall rather than a hypothetical which involves, in fact, not making it good at all.
Thank you.
And the irony, so your lordships have my point in relation to Rule 21, and the irony, therefore, as to the respective implications of the parties' contentions does not end there. As will be apparent, it extends to Article 7.1. On the trustees' construction, contributions are maximally got in fact, and the Article 7.1 filling the gap, balance of cost liability, is correspondingly reduced. By contrast, on the appellant's submission, with no contributions coming in fact, the Article 7.1 filling the gap balance of cost liability is unreduced. The net position is then described at paragraph 14.3 of the supplemental skeleton over the page at 153.15. And you see, and you will have seen at 14.1 and 14.2, the interesting progress as to how we have actually got to where we now are, in this case at paragraph 14.3, in relation to the changing focus and nature of the appellant's submissions. Now, so far as regards paragraph 14.3, just reading through it, if you would kindly do so. To fill in, as it were, you see the 4.3 million is the reference to the increase in the shortfall, which would be attendant upon the active member opt-out by virtue of the effect of preservation and the revaluation and deferment. The missing figure from 14.3 is the 18.1 million, which is the existing Rule 21 shortfall, as calculated by the actuary for 2019. And we will come in a moment to see what the actuary said in relation to it. That 18.1 million is what is to be dealt with under Article 7.1, this valuation cycle, if everyone opts out. Opt-out may be expected to increase the shortfall by 4.3 million, and that will be picked up in the next valuation cycle and fall to be dealt with in the next Rule 21 shortfall under Rule 21.13, which then steps in. And as you know, Rule 21.13 wasn't there until 2006. It would have had to have been Article 7.1 up till 2006. Now, the position arising out of the appellant's acceptance of the option B approach is, as just described, seemed and seems to be clear enough. Their Article 7.1 liability, as night follows the day, is £18.1 million. However, listening to my learned friend yesterday, and it's day 1 transcript, page 120, lines 2 to 11, you could get that up, and he's repeated it this morning in his submissions to you. At day 1, page 120.
I thought we were going to be given hard copies of the transcripts this morning of yesterday and so on. In fact, we haven't been. But,
Well, you evidently, my lord, if I may say so, should have been, and I wasn't aware of that, and I apologise.
It seems a shame to make that economy. But anyway, you have
Day
referred
one,
to day one,
page 120,
120.
lines 2 to 11.
Yes, they are on screen.
If you look at 119, 19 to 22, the context, my learned friend, the effect of 7.1 is to deliver through the duty, to be engaged in relation to that duty, whatever it is, that which is deliverable under 7.1, and we say that means, and then he goes on to explain the outcome at 120, 2 to 11. The outcome, we say in the rules, is that the employer and the members will be liable for increased contributions under Rule 21.1.2, and those are future contributions which in the case of the members have to be brought into account. So he wants to take into account the Rule 21.1.2 contributions as set, but which will never be collected as a deduction from Article 7.1. They are not the contributions they are paying at the moment, they are the ones they are going to once the valuation process is effective. And those contributions must be taken into account expressly under the concluding words of 7.1. So he was taking credit yesterday in the calculation of the Article 7.1 liability for contributions under Rule 21.1.2, which are never going to be got in because everyone's going to opt out. And this morning, if I understood him correctly, he was also taking credit in the Article 7.1 calculation for the fact that people's future service benefits would disappear and the future service contributions in relation to those benefits would also disappear. Now let me explain to you.
Future service benefits would disappear, but only for the active members.
Oh, indeed.
I do wonder, perhaps this is a naive question, but why is anybody still there? Why have 29 members remained in the scheme?
Because my lord, they regard the benefits, plainly, that they're receiving under the scheme as value for money. They're making contributions of, I said 11.38% yesterday, I should have said 11.68%. They're making 11.68% contributions pursuant to the 2013 Rule 21.1 STEM agreement. Those were contributions of 10 years contributions. In fact, they're coming to an end this year, and their contribution rate's going to drop back to 8%. Yeah? So, but they think that they are getting value for money. That's the position. Now, can I just explain to you what's wrong with my learned friend's submission?
Yes.
So, listening to my learned friend yesterday, we did wonder whether the appellants, whilst accepting that Article 7.1 would fill the gap this valuation cycle, were attempting to reserve a possibility of arguing that, in filling the gap, Article 7.1 did not impose a sufficiency of funding liability, calculated by reference to the whole of the 18.1 million shortfall, which as a matter of fact would remain unaddressed. That the appellants would somehow wish to take credit for the purposes of ascertaining the amount of their Article 7.1 sufficiency of funding obligation, for the value of uncollected contributions under Rule 21.2, even though they were never received and never going to be received. And further, and this was this morning, that the appellants would wish somehow to take credit for the purposes of ascertaining the amount of their Article 7.1 sufficiency of funding obligation, for the value of future service benefits reduced, even though they would, and this is the really important point, even though they would neither accrue nor be paid for. And so the reduction in their value would effectively cancel out in the Rule 21 shortfall balance sheet, which includes prospective contributions as well as prospective benefits in getting to the £18.1 million figure. I'm going to repeat that because it's absolutely key to understanding the smoke and mirrors that's going on here. It's plain the sleight of hand in relation to Rule 21.1.2 that they wish to take credit for contributions which are never going to be received under Rule 21.1.2. This point is that the appellants wish somehow to take credit for the purposes of ascertaining the amount of their Article 7.1 sufficiency of founding obligation for the value of future service benefits reduced, even though they would neither accrue nor be paid for, and so the reduction in their value would effectively cancel out, excuse me, in the Rule 21 shortfall balance sheet, which includes prospective contributions as well as prospective benefits in getting to the 18.1 million figure.
Now, this, I'm so sorry you said it twice, but I'm going to ask you to say the last part again. They want to take credit under Article 7 for the value of future service benefits reduced, despite the fact that they won't accrue and won't be paid or be paid for in terms of contributions. Then you go on about cancelling out. Can I have under Rule 21?
Yes, but the point is, my lady, and I'm going to explain it a little more. I'm going to show you the actual figures in a second to make it good.
Okay.
But the point is, the Rule 21 shortfall is a combination of a past service shortfall, yeah, and a future service shortfall. Yeah? Yeah. In this case, as it happens, I'm going to show you it. The past service shortfall is 17.9 million of the 18.1 million. Yeah? Yeah. The future service shortfall is 0.2 million. That is, future service benefits are valued at 5.3 million. Future contributions are valued at 5.1 million. And then there's a provision for 0.2 million of investment over performance. Okay? I'll show you it in a second. All right? If you take away the value of the 5.3 million on the basis that future service benefits are not going to accrue, having regard to the nature of the Rule 21 shortfall calculation, you also have to take away the contributions that you're not going to receive in respect of them, which is effectively 5.3 million, 5.1 million plus 0.2 million of investment return. So what's going on here is that the appellants are seeking to take credit in the Article 7.1 calculation for the removal of the future service benefits and the removal of their value, when in fact that doesn't reduce the Rule 21 shortfall at all. And I'm going to show you the figures. The reality check comes from paragraphs 8.2, sorry, forgive me, paragraphs 2.8 to 2.20 of the Willis Towers Watson's, the scheme actuaries note at B22 314. B22. And it won't take me very long to finish this point, in order to say if the transcript right will just indulge me. B22 314. And and it's 228 to, I said 220, I'm terribly sorry, I meant 213, terribly sorry. Paragraphs 2.8 to 213, they're all on page 314. Now, the precise figures may not be agreed because the 2019 valuation hasn't been agreed, but the illustration is clear enough. And your lordships should bear in mind for this purpose that, as you will have noticed yesterday, the Rule 21 valuation is done under Clause 6b, in relation to which the actuary needs only to consult with the employer. The reason why we haven't got a 2019 valuation agreed or a 2016 valuation agreed is that, as appears from Clause 6b, the valuation has to be done in conjunction with the Part 3 of the Pensions Act valuation. And for that purpose, the trustee needs to have the consent of the employer to the methods and assumptions in the valuation. That's section 229 of the Pensions Act 2004, which isn't in your bundle. You've got sections 222 to 224, I think, but not 229. So these figures are reliable because they are the product of consultation between the actuary and the employer in relation to something in respect of which he doesn't need agreement. Now, let me take you through the highlights of 2.8 to 213. The Rule 21 shortfall is £18.1 million. That's at 2.8, you see that. And here's an important point to see one of the fallacies of my learned friend's submission. It includes, as you see, an accrued benefits deficit of 17.9 million. And that throws light on the heresy of the appellant's submission, that whereas a past service deficit needs actually to be repaired, this sort of deficit doesn't. The truth is, this sort of deficit has got a past service component and a future service component. And here, 17.9 million of it is past service, and the whole of the Rule 21 shortfall being calculated so as to take account of future service deficit as well. Now, as a result of Atos not lifting the 130% cap, additional contributions, that's participating employer and active member contributions under Rule 21.1.2 would be 0.9 of a million. That is paragraph 2.9. As a result of Atos not lifting the 130% cap, additional contributions from employers and active members under 21.1.2 would be 0.9 of a million. That's 2.9. But the same will never be collected. So the identification of such contributions makes no contribution to the reduction of the shortfall on the balance sheet. And that's paragraph 2.12, leading into paragraph 13. Then back to paragraph 2.9. Elimination of the cost of future service benefits accounts in theory for £5.3 million. However, 2.9 and 2.13, that is balanced by the future service joint contributions, 0.1 million plus, as I say, 0.2 million assumed investment return, which will not be collected in relation to the same. And that punchline at 2.13 will mean that if everyone opts out, the 18.1 million shortfall is not even hypothetically, arithmetically accounted for. So, on the trustee's submission, option B inexorably leads to the appellants being liable for the whole 18.1 million, and that this attempt, which I pointed out from the transcript and is elaborated this morning, to try to minimise the Article 7.1 liability, has actually got no substance. That is the Article 7.1 liability, and any suggestion to the contrary arising out of my learned friend's submissions should not be left open at the end of this appeal. Otherwise, we're just going to have another argument. Would that be a convenient moment?
Break off?
Yes, please.
Okay, 11:45.
Thank you.
If you win.
If she records the submission, that's what she was doing. Anyway.
I was
see what you mean. Even if, yes, I see. Anyway, I'm trying to think. You? What I'm actually finding out. I've got and then we could now come to me. Generally speaking, ask yourself the right question. Obviously, as long as they ask Brian.
Yes.
Well, distinguished or not, I noticed in the Frank's pension these age tokens
Okay. Yeah.
still around. One gets
Yes.
not placed in well, one reason why, many reasons. You want to go to the I have been for the last 2 years. I've been doing other things. Because with 3, I probably would still go. Mostly to support my juniors. And introduce them to people. But as a
Yes.
for the reason you identified. The dinner first night is always quite fun. And, you know, given your age, I know you want to see the interesting, you know. No, please do. Yeah. Age appropriate. You need,
Now I realise during the Sunday. No, I haven't. Yes, I thought it was reasonably clear, wasn't it? That we were saying under our Rule 21, just he then went on to say these stipulation in respect to something which doesn't. Yeah, and for that vote. Okay, he needs to say. Yeah, yeah. Well, indeed. I see, yes. A friendly guy. Indeed. You're only only a little bit to typhoon in the teacup. Yeah. So you involved in this? Are you here for another case? Yeah. He's got a case in January, which is why there was this spat about Anyway, no comment. We've got hard copies of transcripts, but they're the 40-page ones.
That's correct.
Is that you?
Yeah, fine, of course. Yeah.
Do you want to hand them out?
Yes.
Like,
Well,
you want me to?
you can do so. Yeah.
Lost the rules. Okay. What the judges are. Didn't see the story.
You sign me.
Do you have your email?
The login details, and you do it. Or do I just know what to do?
Is it
No, they're here. I don't mind you seeing them. You're going to do this more frequently. I'll watch you.
But if that doesn't work,
I'm going to get out of the way. It's really difficult to type for me. Outer temple. A-O-U-T-E-R. Outer. O-U-T-E-R. Outer temple.
Right, okay, I'll make a note. Oh yeah, no,
Edward, what's the top box?
yes. Yes, no, sorry, yeah, so I think yeah, no, I think
I get the point, so I don't forget it. I get the point. I get it. Article 7 is way down the line. Yeah, yeah.
Right, thank you. There's also this sickness.
given them copies?
You just
Have you printed them out now?
I've done that.
Sorry?
Yeah, the council gives me to hand out.
All right, so they've got copies.
You keep making note.
My lords. Rule 21.
Yes.
If your lordships could have in front of you B13 218 to 219. That is Rule 21.
Yes.
You've looked at it many times. We will be looking at it again on several occasions, but it's just so that it's to hand. Now, the trustee's case in relation to Rule 21 can be summarised in the following propositions. Some are shorter than others, but I hope that you will bear with us as we make them, because in our respectful submission, their cumulative force is overwhelming. And we hope, again, without wishing to sound presumptuous, we hope that cumulatively they will serve up to you on a plate the answer to why the Chancellor got it right in this case and why the appellants are wrong. The points are 18 in number.
Good heavens. If at any point you want to say you will find this point in paragraph X of the skeleton argument, do so, otherwise we'll just sit there and write them down.
Lovely. And your lordships have the transcript, obviously. The first point, the very basic one, from which we're all agreed, the meaning of the word determine. Point 1, determine. Now, as Sir Launcelot observed, the primary meaning of the verb to determine and its cognates and its meaning in the present context is to decide, settle, conclude or fix. Decide, settle, conclude or fix. And if there were any need to found the proposition in source material, it appears clearly from the OED, D425788, at heading 2, it's a matter of ordinary language. Point 2. Determine conveys a substantive discretion involving professional judgment in this context. A pensions actuary is not, to pick up on my lady's observation to my learned friend yesterday, a mere number cruncher, which is the straitjacket that the appellants would have applied to him in relation to the determinations that he is empowered to make and which are presently in issue under Rules 21, 1, 2 and 4. Learned friends recognise a discretion in relation to other determinations, but in relation to this particular determination, which obviously where it doesn't suit their case, they wish to place him in a straitjacket. The word determine, meaning to decide or to settle, conveys the conferment on the person having the power of determination, a substantive discretion to be exercised in accordance with his or her judgment. Such discretion has, of course, to be exercised in accordance with the scope and purpose of the power in question, but it is a substantive discretion nonetheless. And I will come back to scope and purpose at point 4. The point is illustrated elsewhere in Rule 21 itself, where in both the stem on page 218 and in Rule 4 at page 219, the trustee is given a power to determine. And that plainly confers on the trustee a substantive discretion as to what to provide for or to allow, and not a straitjacketed mechanistic role.
But may not the reason for that be that it's because he's a trustee that he inevitably has to exercise it in a fiduciary capacity, whereas an actuary is not a trustee?
But the whole debate has been, but yet he's to be equated with a fiduciary. And indeed,
yes.
at point one, my lord,
Sorry,
forgive me, and point two is, I think we're all agreed that actuaries, in their professional judgment and discretion, in their professional activities, inherently exercise judgment and discretion. That's what they're there for, to advise.
Definitely they exercise judgment. I mean, no problem at all with the concept of professional judgment, which involves all sorts of making difficult decisions on value judgments, things of that kind. But when you talk about a substantive discretion, what quite do you mean by that?
Well, I mean that he actually engages his mind and decides between alternative courses according to his decision-making processes, applying professional judgment to it. I'm using discretion in a conventional sense.
I mean, is it a sort of subset of his professional judgment, or something operating alongside it? I'm
It's
just getting a
part of
little uneasy. It might be.
My lord, my respectful submission, it's part of it.
It's part of it.
Yes, discretion exercised in accordance with professional judgment and professional standards, applicable to the particular task in hand, as trammelled by actuarial guidance, but discretion nonetheless. It's down to the actuary. And well, I'm not going to go on a goose chase through all the actuarial materials, but the one thing that comes out of them loud and clear is, for all we're saying, the actuary has got considerable latitude to come to his own decisions as to what methods and assumptions he's actually going to apply in all the circumstances. But we'll come on to
All right, sorry, I don't want to.
No, I anticipate, my lord, if I say so, I anticipated there might be this discussion on this particular point before we get on to some
it's
real
important
meat.
because, to a trust lawyer, discretions on the whole, one thinks of them as vested in, or particularly in trustees. Or, of course, no, it can be discretions to choose between beneficiaries, all sorts of types.
Power holders.
Power holders.
And what's been, well, this is really important, my lord, if I may say so,
Yes.
because what's been conferred on the actuary here is a power.
Yeah.
Right?
Yes. Yes.
So that's the debate between us. But
Thank you.
this will progress, I promise.
All right, well, can I just contribute to Pennyworth? You said the decision must be exercised with professional standards and judgment. Of course it must. That's the easy bit. But it seems to me that what you focus on is the discretion to decide between two alternative courses, or two or more alternative courses, not simply a duty to get out what used to be a slide rule and find it the only one answer.
Correct. And my lord, I will submit to your lordship, actually, that's an essential part of the actuary's advisory function generally. You can say that actuaries do calculations, but in fact it's not simply getting out a slide rule or a calculator. They're behind those calculations, whether you call them determinations, calculations, there are a mass of decisions being made, as to choices being made in discretion as to what should be applied in the particular case. But please, I'll develop this.
Okay, was that point two? You
No, but I haven't quite got to the end.
You haven't got to three. Oh, you're still on two. Right. Okay.
I had a feeling this might happen too. The moment I said 18 points, I knew this was going to happen.
Well, you were not expecting us to sit there and copy down 18 propositions before asking a question.
No, not at all, my lord. But I do commend the transcript.
Right, keep going.
Okay, so in the case of the actuary, as was already apparent from my lady's exchanges with my learned friend, in relation to rules 21.1.2 and 4 yesterday, that's day 1, 101.12 to day 1, 104.24, we don't need to get them up. And as we shall see when we come to deal specifically with the point throughout Rule 21.1, such substantive discretion involves many and various exercises of professional judgment, which a specialised pensions actuary is well qualified to bring to bear, indeed which, in his capacity as actuarial advisor, he would be expected to bring to bear in deciding, settling, concluding, or fixing a matter entrusted to him. And those professional judgments involve in making, and this is important in light of Sir Launcelot's point yesterday, those professional judgments involve making all sorts of judgments as to the future, such as to future pensionable payroll, which involves judgments as to how many members are expected to remain active and for how long, and what their remuneration at key points for benefit calculation is liable to be. What is their final salary likely to be? And that's not merely a feature of a past service benefit valuation method, it's also a feature of a future service benefit valuation method, where it is expanded, these assumptions as to the future expand in the case of an exercise such as the Rule 21 shortfall exercise, in the case of an open section, to assumptions as to future joiners and contributions and liabilities in respect of them. So if it's a past service method, it will look at the present membership and make future assumptions in relation to them at all stages in the actuary's process and in relation to the exercise of powers by him. And in the Rule 21 shortfall exercise, in the case of an open section, similarly, the actuary will be looking to the future and making assumptions in relation to future joiners and contributions and liabilities in respect of them. Now, this kind of long-term looking forward is central to the actuary's function. And as Sir Launcelot observed yesterday, page 107, lines 18 to 25, looking at the short-term prospect of opt-out in this connection is no different. And for confirmation that it is no different, I will refer you, but I won't take you to it now, to B22.316, paragraphs 3.9 to 310, B22.316, paragraphs 3.9 to 310, where the scheme actuary confirmed that taking account of opt-outs was part of the standard actuarial process. Point 3. Determination and calculation. Granted that determination can include calculation and that a determination may in context be complete upon completion of calculation, there is no reason to cut down the meaning of the word determination, especially where, as here, what is in issue are matters inherently calling for the exercise of judgment as to reasonableness and fairness, namely, 1, increasing what active members are paying for their benefits, and 2, whether active members' rights to accrue FSBs are to be withdrawn from them. My learned friend rather gave the game away on this yesterday when Lady Justice Asplin was pressing him as to the existence of judgments on the part of the actuary in the making of determinations throughout Rule 21.1.2 and by extension Rule 21.1.4 in the passages in the transcript already referred to, 101.12 to 104.24. But my learned friend himself gave the game away as early earlier on in his discussion of Rule 45.5. And if we could go to day 1, page 63, the giveaway is at lines 18 to 23. Page 63, lines 18 to 23. So Rule 45 is set in the context, as you'll see from page 61, line 12. It's the discussion of Rule 45.5. And this is my learned friend making the point that under the BRPS there was contributions as shall be such as to make good the shortfall in full submission. And then, my learned friend said at lines 8 to 10, but as regards such contributions, he has some discretion about the rates and periods, and that additional amount shall be payable through and for. And my lady said to him, but Mr. Spink, what do you mean by discretion there? He has some discretion, you say. And my learned friend said, yes, in terms of the rate and period he can use his judgment as to what the appropriate period should be. It is use his judgment, said my lady. Yes, said my learned friend. Use his judgment on that, certainly. And one would expect in a scheme of this sort, particularly one where one was effectively committing the members to significant contribution increases, that you would spread that over as long a period as possible so as to reduce the rate of the minimum amount per month or year. So affordability and hence collectability were recognised as concepts when it comes to setting the rate and period, but apparently they're not concepts when it comes to setting the contributions themselves. Point 4, scope and purpose. The scope and purpose of the powers to determine conferred on the actuary under Rules 21.1.2 and 4 second limb is concerned with making good the shortfall. And I'll come to the precise meaning of that expression at point 7. That being so, there is no good reason to read down the actuary's powers to decide or to settle increased contributions, or to decide or to settle reduced future service benefits, so as to require exclusion of consideration of the extent to which setting unrealistic contributions or extinguishing future service benefits is actually going to make good the shortfall at all, or even worsen it. Indeed, to the extent that the setting of unrealistic contributions or the extinction of future service benefits is going to be counterproductive in making good the shortfall, by comparison with a more measured response, there is every reason for reading the actuary's powers to decide or settle such matters as enabling determination by him in his professional judgment, which best serves the objective of making good the shortfall, rather than mandating a response which will fail to do so. It is in our submission plain, notwithstanding what the appellant submitted in the skeleton, that my learned friend has not advanced on his feet, it's plain that the designated employer, acting subject to its imperial duty, and the trustee in its fiduciary capacity, when they decide whether, and if so what, to agree in relation to making good the shortfall, whether under the STEM or under sub-rule 4 first limb, they are entitled to, indeed we would say they are duty bound to, take into account the extent to which what is proposed will render additional contributions unaffordable or future service benefits earned by such additional contributions nugatory, so as in each case to render future contributions uncollectible. It is correspondingly plain that the actuary, exercising his powers in default of any such designated employer and trustee agreement under the stem or the first limb of 4, to determine contributions, increases and reductions to future service benefits, powers that the appellants are keen to characterise also as fiduciary. That's paragraph 50 of their skeleton, A9115, and as discussed today. It's plain that the actuary exercising his powers is entitled, indeed duty-bound, to take such matters into account if he is not to undertake a process indifferent to whether contributions are to be collected and which leaves the shortfall unaddressed or even worsened as a result. So, pausing at this point, point 5. In short, a construction of the power to determine conferred on the actuary under 2, which entails no actuarial discretion, but to set contributions which are not going to be collectible, say contribution rates of 100% or more, as you'll have seen referred to at paragraph 10.1 of our skeleton, footnote 5 at 810.128, where the current contribution rate for employees absent the cap would be 125%. And my lord, I should say the number of actives is 25 at the moment, not 29, as discussed yesterday. So, a construction of the power to determine conferred on the actuary in 2, which entails no actuarial discretion, but to set contributions at levels which are not going to be collectible, say contribution rates of 100% or more of section pay, as here, see paragraphs 10.1, 37.1b, and 50.5 of our skeleton, is not a construction of the power to determine conferred on the actuary consistent with the scope or purpose of such power, being to make good a shortfall. And similarly, a construction of the power to determine conferred on the actuary in 4 second limb, which entails no actuarial discretion as to whether future service benefits should be eliminated, thus extinguishing in the process the prospect of future contributions, is not a construction of the power to determine conferred on the actuary consistent with the scope or purpose of such power, being to make good a shortfall. The other side's construction is not consistent with the scope and purpose, and the scope and purpose comes from the final words of the stem, to make good the shortfall, which is plain, that's the scope and purpose of everything in Rule 21. Point 6, perspective. The point is this, point 6. Collectability will always be a relevant consideration under Rule 21, but whether it is a limiting consideration will depend on the facts. Collectability will always be a relevant consideration under Rule 21, but whether it's a limiting consideration will depend on the facts. Collectability may not be an issue in many cases because contributions may be set under Rule 21.1.2 at collectible levels. Look at the 2013 case here where what was agreed was 11.68%. Or because even if some future service benefits were to be pared back under 4, value for money concerns would not impact collectability of contributions. So collectability may not be an issue in many cases because contributions may be set under 2 at collectible levels, or because even if some future service benefits were to be paid back under 4, value for money concerns would not impact collectability. Rule 21.1.2 and the 130% cap may operate perfectly meaningfully in such cases, with potential scope for future service benefits still being value for money for active members, particularly given that employers are paying 60% of the cost of accrual of the same. And to give you a small example from the facts of this case, your lordships will have seen that and this comes from B15 236, which we looked at yesterday, that applying the 130% cap, you get to a member contribution rate of 13.36%. You'll also have seen that at some point in the past, and I don't begin to suggest that that is now the present position, the ship may have sailed. At some point in the past, and this is Hannon 2, paragraph 17, B19 263.2, at some point in the past, the trustees under the stem said to Atos, how about a member contribution rate of 17%? Now, implicit in that was a recognition then that 17% was affordable by members, because the trustees would never have put it forward. Now, transpose that across to the 130% cap imposing a 13.36% limit. Logically, and I'm not suggesting that the maths is entirely congruent and symmetrical, I'm no actuary, yeah? But logically, if 17% for the existing future service benefits is okay, then 13.36% for slightly curtailed future service benefits under 4 is also okay. I'm not saying that it's a direct congruence. I'm not saying that you can pare back to 13.36 numerator over 17 denominator of future service benefits. But I am saying that this demonstrates just how 2 and 4 could potentially work perfectly well, perfectly tolerably, without in any way undermining the operation of the wording of 2 without the cap, the wording of 2 with the cap, and the operation of 4. They can operate perfectly meaningfully. And this is a further insight to a point which I'm sure you've already got, as to the limits of the circumstances in which Article 7.1 might cut in. Because it's entirely possible to have 2 and 4 work, in many cases, without getting to a point where the whole of the shortfall is not eliminated. But, if there are cases where the whole of the shortfall is not eliminated by their practical operation to actually get in contributions, reducing the shortfall, then Article 7.1 fits in.
Do I understand by that that you're saying that 7 comes in after 4?
No.
Exactly, I just need to...
No. If I say so, bullseye. No, I'm saying that there is nothing in... I want to talk to you about when it cuts in.
Yeah.
It's a separate exercise. Obviously, yes, no, entirely right, lady, if I may say so. Without prejudice to the question of whether it cuts in after 2 and 4, just supposing against us, and as I've said all along, we perfectly see the point, yeah? Supposing against us that Article 7.1 cuts in after 4, yeah? It's perfectly coherent to see 2 and 4 having an operation without Article 7.1 ever having to be troubled at all. Now, what's actually happened, in fact, is that in cases where 2 and 4 have not been capable of coherent operation, the 310 cases referred to by Mr. Hannon in Hannon 1 at paragraphs 44 to 46, B14 227 to 228, and then again Hannon 2 at paragraphs 16 to 20 at B19 263.2. In the 310 cases where it hasn't been possible to operate 2 and 4 collectively, affordably, fairly, other employers have agreed under the stem a departure from 60/40. That is what paragraph 45 of Hannon 1 records. And Article 7.1 has never been needed to be used in those cases either. But it's always been, as it were, sitting there behind those agreements, even though this is the first case to actually have where a challenge to its operation has been mounted, and so the consideration that it may exist behind the agreements is actually being put under the microscope. Point 7, the meaning of contributions. This is a key construction point on Rule 21 when you come to consider Rule 21.1.2. Rule 21.1.2 is concerned with the determination by the actuary of contributions, including the determination by him of the rate and period over which such contributions are payable, with the view of making good the shortfall. Contributions means things that are to be got in, things that are to be paid and received. That is the meaning of a contribution. The reference in 2 to the rate and period which is to apply in relation to such contributions only serves to emphasize that that which is being referred to is something which is intended to be real and practical and to happen in fact. It is the heart, it's at the heart of the actuary's function, and the role conferred on him under 2 entirely conforms to this, actually to address the funding position of a scheme, to do so by the ascertainment of liabilities and then the certification of contributions, that is, actual amounts to be paid and received, the actual crediting of which will actually go towards addressing the funding position in fact. Contributions are real and practical things to be got in as a matter of language, as a matter of general understanding in the occupational pension scheme context, and under Rule 21.1.2 itself. Contributions are not a mere abstract mathematical construct, and this is the word used twice in relation to the contributions obligation under Rule 21. It's a construct according to the appellant skeleton at paragraphs 51.2 and 54.3, A9116 to 117. Contributions are not a mere abstract mathematical construct, such as the appellants contend for, being mere calculated amounts, which the actuary, the trustee, and the designated employer know will not be paid and received, and so not contributed at all.
Could I just chip in and ask you how that fits in and the drift of what you're saying, which is you've got to look to the actuality and the collectability, how that fits in with little 2 having the cap of 130%, which therefore assumes within little 2 that you might be getting to serious percentages and drags with it, because of the 60/40, what the employee, the member, would be paying. How do those... are you going to get that?
Yeah, but it actually makes the point for me. Thank you, my lady. Because why does the employer impose the 130% cap? Because he doesn't want to actually pay the contributions. He doesn't impose the 130% cap because the contributions are some mathematical, hypothetical construct which he finds emotionally upsetting. The whole case on this is a chimera, the appellant's case. The reason that the 130% cap is there is to enable the employers to say, I don't want to have to pay 60% of this increased contribution rate. I'd rather you perhaps now look to see whether future service benefits can be reduced under 4. The 130% cap is a dispositive proof that we're talking about actual contributions and not mere hypothetical constructs. And the point is further emphasised by Rule 3A itself, the employer's contribution obligation at A13207. Sorry, B13207. I apologise. B13207. If your lordships have that, it says each participating employer shall contribute. Not shall constructively contribute, hypothetically, objectively, but not really. Each employer shall contribute at a rate determined by applying the multiple of 1.5 to the amount contributed by members under Rule 3B. That means actually contributed, not hypothetically to be contributed by members. The contributions actually required to be made by employers under Rule 3A are defined by reference to the members' contributions described under Rule 3B, which members' contributions, being actual contributions to be paid, got in and received, include, and here's the punchline, which further deflates the appellant's case, those members' contributions, 1.5 times which the employers shall contribute under 3A. Those members' contributions, if you turn the page to 208 and look at Rule 3BA3, those employers' contributions that the employer is obliged to contribute at the 1.5 times rate under 3A include Rule 21.1.2 contributions, such rate as may be determined by the actuary in respect of the member in accordance with Rule 21. The appellant's case that the application of a prospective benefits funding method to establish the shortfall, and they became quite Melendra and became quite careful as to whether he was making an actuarial point in relation to that. Let me be clear, Rule 21 does contemplate something in the nature of a prospective benefits funding method. Yes, it does, because it takes into account future service, future contributions and future benefits. It's not simply past service orientated. Yes. But the appellant's case that the application of a prospective benefits funding method to establish the shortfall, that entails the use of mere abstract calculated amounts, which the actuary and the trustee and the designated employer know will not be paid and received, and so not contributed at all, is, to use the Chancellor's description, which the appellants happily embrace in their skeleton, a lawyer's construct unsupported by actuarial practice or principle, or frankly, with respect, common sense. I'll return to this at point 18, the actuarial points in this case. Now, the other key expression in Rule 21, in issue in the present case, requiring construction, is making good the shortfall. And the interpretation of this brings me to points 8 and 9. Point 8, making good the shortfall, first point. It's important to recognise that Rules 2 and 4 have never provided comprehensively for the making good of a shortfall, and do not do so even on the appellant's interpretation today. The punchline on this is at paragraph 12 of the trustee's skeleton at A10 129 to 130. Paragraph 12 of the trustee's skeleton at A10 129 to 130. And if I could ask your lordships just to remind yourself of this, there's actually nothing really between us on this. Paragraph 12 basically sums up, as indeed is reflected in our supplementary skeleton, the real issue in this case. Both sides recognise that the shortfall will not inevitably be made good by the operation of 2 and 4. Whether the Chancellor was really inserting the words so far as make good, so far as practicable in at the end of the stem in order to make his point concerning the relevant construction or not, and whether or not that was heretical, is not the point here. And I think it can be taken as a given that the Chancellor knows his onions and does not go around inserting words in order to construe them.
Yes,
but,
I certainly didn't mean to suggest in fact doing that.
No,
I'd rather give the impression at one point.
No, it's... I will say no more on the subject, but obviously he knows what he's doing. The point is, the real point is, and the point that we were making when we said read in the words, as appears from the transcript, you don't have to bother by it, was that both sides agree it's so far as practicable, or so far as the application of 1 to 4 will permit. We both agree that. The question is, what does that entail? So when you actually approach this question, when you approach the words at the end of the stem, shall mandatory, be made good as follows, it is conceded by the appellants to mean, without reading in words, shall be made good so far as the application of 1 to 4 will permit. And that is what's expressly stated at paragraph 62 of their skeleton at A9 120. And that concession leaves this court with the question of what that limitation entails. And it pulls the teeth of the significance of those words. Because we both agree that they don't inevitably involve the conclusion that the shortfall shall be dealt with completely. Now, unpacking this point, it's significant in this connection to start with the original version of Rule 21. And if I could just invite you, please, to go to B4, 50 to 51. And I know you've got this point, but I think it's a nice way to get into it, to look at the modesty of the original version of Rule 21. B4, 50 to 51.
This is still point 8.
Yes. My lady, I did say some are longer than others. Now, as your ladyship will see, and as your lordships will have noted, the expressions make good the shortfall and the shortfall shall be made good in the following way have always been features of Rule 21. In the stem, the first reference is to make good the shortfall relates to the designated employer and the trustee and what they might agree. And the subject of that, the shortfall shall be made good in the following way. Those words have always been there.
And they were in 45.
But they had, yes, they do come from 45. Oh, sorry, they're also found in 45, but they function differently in 45. And then the shape of Rule 21 is, and let's just pick this point off. You notice, in fact, that paragraph 1 functions separately to 2 to 4, because the way in which it's actually constructed, and this continues to be the case, is that if there's a Rule 21 shortfall, paragraph 1 applies first. And that mandatorily places the balance of cost, the entire liability, on the employer. Yeah? And it's subject to that we get into what was then only 2 and 3, equating to what is now 2 and the first limb of 4. Okay? And so the words to make good the shortfall, as I say, govern what might be agreed between the designated employer and the trustee, which may or may not make it good in full. But subject to that, the arrangements to make good the shortfall, the shortfall shall be made good in the following way. And then, when you go to 2 and 4, the position is clear. There was, if you look at 2, there was nothing under then 2, or subject to it under then 3, which equates to the first limb only, which required, much less ensured, that the whole of the shortfall would actually be made good, given. First point, the 130% cap under 2, that is the cap of 1.3 times the cost of future service accrual, meant, and has always meant, that the extent to which a past service deficit would be addressed under 2 is inherently limited, unless the designated employer, which has ex hypothesi already refused to come to an agreement under the stem, agrees to lift it, which, as we've seen, Atos has not done so here. So the fact is that you've got the 130% cap, which means it's inherently limited in the extent to which it can address the shortfall if that's insisted on. But you've got the further point that its ability to deal with past service deficits, given the 130% cap, is inherently limited. Because the 130% cap is a cap on the cost of future service accrual. It's 1.3 times the cost of future service benefits, the normal long-term funding rate. And that's only going to make a 0.3 times, if you like, impact on past service deficits. So, point 1, 2 was never comprehensive. And point 2, in relation to subparagraph 3, there was and is no requirement under little 3, with its first limb only, for designated employer and trustee agreement. The reduction shall be as may be agreed between the designated employer and the trustee. But absent agreement, there is no reduction. And further, under this point, and further, this provision can't impact a past service deficit either, because it's only concerned with future service benefits, unless you take the view that unrealistically future service benefits would be reduced to 0 and members would keep on paying, and then past service deficits would be dealt with by members paying for the past service deficit but for no future benefits. I think we can forget that one. So that second point is that 3 is inherently non-comprehensive as well. Designated employers and trustees need to agree it. If they don't agree it, there's nothing you can do about it. And further, it's not equipped to deal with the past service element of the deficit, which, as you've seen from my submissions earlier, in this case is £17.9 million out of the 18.1 million. Now, the non-comprehensive nature of what is provided for under in 2 and 3 in the original formulation remains the position in relation to those provisions, with the addition of the second limb to what was originally 3 and what is now 4. And if we go back to B13 to 18, 19, to 19, B13 to 18 to 19, all the same points as I've made in relation to 2 remain. They're the same as I made first time round, because 2 hasn't changed. And in relation to 4, the points are similarly so. In relation to 4, any reduction in future service benefits, even if my learned friends are right in relation to the second limb of 4, which we respectfully say they're not, that's only going to deal with future service benefits. It's not going to address past service benefits. So the position is that we come back to paragraph 12 of our skeleton, A10, 129 to 130. The words at the end of the stem shall be made good as follows are conceded by the appellants to mean so far as the application of 1 to 4 will permit, and that leaves the question with the court of what that entails. And you've got our point, our first point, 8 on making good the shortfall, that it's always been non-comprehensive inherently. So when it says shall be made good in the following way, you have to take that into account, which is then our point 9. The second point on making good the shortfall. The words, the shortfall shall be made good in the following way. In light of this analysis, when the point 8 analysis, when you come to look at the expression shall be made good in the following way, it is to be understood as it says itself by reading and applying the words in the following way, with and subject to the limitations inherent in what follows. And what follows does indeed convey, we would suggest, I mean, frankly, the point I've just made, we would suggest is freestanding and, in our respectful submission, irresistible, but we'll develop it. And the what follows, in the shortfall shall be made good in the following way. And what follows does indeed convey a meaning of make good, which might be said to correspond with ordinary usage. To make good means to repair, but it doesn't necessarily mean to make as new or to do so perfectly. It's not necessarily the same as to make whole. And whilst it may be, I fully accept, whilst it may be that in context, make good may mean make whole. Get that? The context supplied by what was provided by 2 and 3 originally, and what continues to be provided for under 2 and 4 today, supports the view that the reference to making good at the end of the stem is inherently non-exhaustive. Now, the judge noted at paragraph 32 of his judgment, A224, that neither of the expression make good the shortfall or the shortfall shall be made good in the following way in Rule 21 had stipulated for the shortfall to be made good in full. And the judge obviously also referred there to the contrast with the rules of the BRPS, to which point I will return my point 17, in due course. And in light of the foregoing, in light of the analysis that in point 8, it's not difficult to see why the draftsman did not say in full in Rule 21 at the end of the stem, because he could not consistently with what was provided for in original 2 and 3 and what is now provided for in 2 and 4 with its second limb, he could not consistently with that have said in full. And the contrast is manifest. First, look at Rule 18E, where B13216, Rule 18E, where it's plain, barely needs expressing, that the draftsman does not have any difficulty with the concept of meeting the full cost of something or providing for something in full in actually expressing it. Second line of 18E, and then after the letters A, B, and C, in full. Could have said it, make good in full. He didn't. But the point is it can be made even closer to home, because in Rule 21.1.1, he uses the expression in full. At page B13218, 4 lines up from the bottom of that page, the payments required of participating employers under 1 have to be sufficient to meet in full the proportion of the benefits attributable to the proportion of preserved benefits by comparison with the whole. He could so easily have said, shall be made good in full at the end of 21. He didn't, and we say for very good reason. I say he could easily have done it. If he'd done it, he would have created a major conundrum for people, because if he'd said made good in full, it clearly couldn't be made good in full. Even hypothetically, on my learned friend's case, because hypothetically, you're going to hit 130% caps, you're going to hit the limits of what future service benefit reductions can produce, you're still going to have past service deficits. He couldn't have said it. He didn't say it in full, and he didn't say, we'd say, for good reason, and rightfully. Point 10. The use of the word shall in the body of 2 and 4 as originally drafted and continuing drafted. So obviously in 2 and 3 as originally drafted, and as in 2 and 4 as now drafted. So the use of the word shall is the same in each such provision, in B451 as well as B13219, and we can take it from B13219, the current version of the rule. We can look at little 2. Rule 21.1.2 provides that contributions of members shall be increased in accordance with Rule 3b. So that's where you start, looking at the members' contributions. And contributions of participating employers shall consequentially be increased in accordance with Rule 3a because of the 1.5 multiple, as determined by the actuary. It is the determination by the actuary which is the source of the increased contribution obligation, subject to his not being able to go beyond 130% of the participating employer's normal long-term funding rate without designated employer agreement. That is what the shall is getting at. The determination of the actuary being a precondition of the obligation arising. No particular increased contribution is being mandated by the use of the word shall, independent of the determination of the actuary. Similarly, under 4, future service benefits for first limb, if you'll come with me on this. For first limb, future service benefits shall be reduced, calculated on such reasonable basis, as may be agreed between the employer and the trustee. It is that agreement that the word shall is getting at. No particular reduction in future service benefits is being mandated by the use of the word shall, independent of what may or may not be agreed between the employer and the trustee. And this point also goes to the argument which my learned friend didn't develop on his feet, the appellant's discretionary trust argument, which, if I've got time, will be our point 14 below. It's plain that the first limb of Rule 2114 is not a discretionary trust under which the designated employer and the trustee are co-trustees who would be subject to the court's intervention under McFarland-Dorton, Rebate number 1, so as to force an agreement. It's paragraph 68 of their skeleton. But I'll come back to that. The important point here is that the operation of the word shall is conditioned by, it's contingent upon the agreement having been reached. So there's the word shall really does not assist the appellants in the slightest in this case. One then comes to the point, and this is going to be my points 11 and 12, one then comes to the consistency of references to determination in 2 and 4 as being supportive of a, as we say, substantive discretion exercised in one's professional judgment in relation to the present issue. And those references and what my learned friend said in relation to them in the High Court are picked up at the judgment at paragraph 68 at A2 pages 33 to 34. And my learned friend very fairly basically said exactly the same to my lady when taxed with these points yesterday. Yes, there's a discretion, and yes, there's a need to form a judgment in relation to this, and yes, there's a need to form a judgment in relation to this, and yes, there's a need to form a judgment in relation to this, but when you actually get to the question in this case, no, I'm afraid there's no judgment, you shall do it, and you've got no choice. And when one approaches this submission as to consistency of use of the concept of determination, you do so with the what the Supreme Court in Bernardo's referred to as the trite proposition, at its paragraph 23, that's D4 tab 22 at 732 letter F. You don't need it, because when I quote the proposition, you'll see why you don't need to look it up. What Lord Hodge said was, one would in principle expect words and phrases to be used consistently in a carefully drafted document, absent a reason for giving them different meanings. A fortiori, we say, where a word in the same provision, not merely the same document, dealing with the same context and subject matter, is being used consistently. So point 11, I'm going to approach this via, because it's a short submission, via Rule 20. And as you'll be aware, Rule 20 at B13 21C 7 to 218 is the sibling to rule in the surplus situation to Rule 21 dealing with shortfall. Now, at 217 to 218, page 218, in fact, the word determines and cognates is used twice in Rule 20 to deal with surpluses. And it's at the end of the rule. The determination relates to whether a surplus is trivial or that it would be prudent to retain the surplus within the section as effectively a reserve. First, determination of whether a surplus is to be regarded as trivial in the context of the section requires judgment concerning the overall scheme of benefit structure and funding of the section. It is not a mechanistic calculation, but a value judgment. Triviality is not a fixed concept. It involves a complex exercise of professional judgment in the context of what's been undertaken, which is a very serious business. The actuary is deciding whether to take a further step by reference to triviality in relation to funding the scheme. So determination, obviously, in that context involves an exercise of judgment, and that has been agreed between my friend and my lady yesterday in relation to Rule 21, but we'll come on to that. Then 2, determination as to whether it would be prudent to retain the surplus or implicitly any part of it in the section. Clearly a matter for the actuary in his professional judgment and discretion, not a mechanistic calculation. Prudence is not a fixed concept either. In each case, the word determine is conveying substantive discretion, and indeed that is recognised in relation to Rule 20 by my learned friends in their manual on this particular point. It's Note 6, B20 273, referring back to their propositions 14.1 and 14.2 on the preceding page, where they say, of both of those determinations, they are, quotes, assessments of complex fact requiring exercises of professional judgment. So, determination in Rule 20, professional judgment. Point 12, Rule 21. Now, as the judge noted at paragraph 68 of his judgment, there are multiple uses of the word determine and cognates in relation to the role conferred on the actuary under 2 and 4, and for that matter 3, and indeed 1, And we would say they all connote professional judgment. They all involve the actuary exercising professional judgment in relation to the exercise of his power to decide, settle, conclude or fix the matter referred to. He's not engaged in a mere mechanistic calculation exercise of a preordained value or amount as to whose preordination in the determination exercise he has no discretion. He's not been told, okay, this is what you have to calculate. He's been told, go away and determine this in relation to 2 and 4. And as is apparent, as we say, from the passages at pages 101 to 104 of the transcript yesterday, the appellants do accept, essentially, what the judge did say at paragraph 68. It's just that they scruple in relation to the issue, in this case, as to the extent of the judgment that the actuary is able to bring to bear. Now, first as regards 21.1.2, the expression determines and cognates is used 4 times in 21.1.2. First, determination as to whether a shortfall is trivial. Well, as with Rule 20, this requires the exercise of professional judgment. It's not a triviality, it's not a fixed concept, and we have seen what the appellants conceded in relation to that, in relation to Rule 20 just now.
Any chance that that list is going to be forthcoming, for example, at 2 o'clock?
Lord, I haven't. I'll take it. Will the list be forthcoming?
Determinations.
No, it's not going to. It's going to. Forgive me. It's not going. It's seemingly not going to be. But let's let people have a chat over the short adjournment and see what can be done for 2 o'clock. You're going to see, my Lord, that there are masses of references to determine, and they are the vast majority are to what the trustees may determine in their discretion and judgment.
Yeah.
Anyway, so
So we're at 2 and a trivial, same point as
Same point again. Determination of the increase in contributions, well, that's the issue before the court. Determination of the normal long-term funding rate. Now, this is set by the actuary in his professional judgment, as my learned friend accepted yesterday, on the basis of a process set out in detail, which I referred your ladyship to yesterday, set out in detail by the scheme actuary at B15, pages 234 to 235, where he explains how he gets to the future service joint contribution rate, and in which, quite apart from all the implicit exercises of professional judgment in the process he describes, he, at his point 5.2d, which is at B15234, he says that he brings fairness considerations to bear in settling the future service joint contribution rate. He does that. And as your ladyship observed yesterday, the future service joint contribution rate is the normal long-term funding rate as defined B13201. It's always been, the normal long-term funding rate has always been the future service joint contribution rate. It's always been a future service based calculation ever since the first actuarial valuation was done in 1994. And when the definition was inserted of the future service joint contribution rate, it was the normal long-term funding rate that was being defined. It wasn't that the normal long-term funding rate was for the first time being defined as the future service joint contribution rate. It's always been a future-looking concept. And then, fourthly, determination of the rate and period over which any increased Rule 2, Sub-Rule 2 contributions shall be collected. This clearly enables the actuary to decide, 1, over a greater or her, 3, with front-end loading, back-end loading, or a flat rate, all in his or her judgment or discretion. So given that discretion and judgment, rather than mere mechanistic calculation of a preset amount, characterises the processes in the first, third and fourth cases, there is no justification in our submission for restricting the actuary to mere mechanistic calculation in the second case. And for the reason given in our points 4 and 5, given that the scope and purpose of the actuary's determination powers under 2 is the making good of the shortfall, bringing to bear professional judgment as to whether exorbitant increases in contributions will address the shortfall at all, or even make it worse, is in the trustee's submission plainly part of the exercise. It's now 1 o'clock.
Good. Shall we break off there then?
So 2 o'clock, but I'll make inquiries as to how we get on with the getting something to you for 2.
Yes.
Thank you.
Thank you.